Ms. Stewart, you may proceed.
May it please the court, counsel. My name is Ashley Stewart, and I represent the appellant, James Mathias. The Brady Street Stadium and its parking lot are not grounds of a school because no traditional academic instruction by a certified teacher takes place at the stadium. And also, the district court judge erred by enlarging the definition of grounds of school with his jury instructions. Under Iowa Code 724.4b, a person who goes armed with carries or transports firearms of any kind, whether concealed or not, on the grounds of school commits a Class D felony. Here, the issue is that the legislature did not define grounds or school. Under Iowa Code 280.2, public school generally means any school directly supported in whole or in part by taxation. That's the only definition we have. So when we don't have a definition, in order to figure out legislative intent, this body must go into what the legislator might have meant or use ordinary definitions of the words. I submit that we should use the ordinary definitions of the words.
Ms. Stewart, is there any evidence that identifies the distance between the school and the stadium?
There is not. We just know that the parking lots, well, we know that they're not connected, and I don't know if they're in the same block or if they're on the same street, but I know that they aren't directly connected or right next to each other. And we know that the stadium has two distinct parking lots.
Would that make a difference in the analysis? So would the result be different if this were a stadium that were on the same campus, like immediately behind a high school versus one that was 10 blocks away and owned or used by different high schools?
I think that would be a better argument for the state in this case, but I submit that you shouldn't look at where the building is located so much, but what the purpose of the building is used for.
Yeah, but if you use the common definition of grounds, if you look into the dictionary, it means the area around the building, not the building itself. So if you were to use that definition, it seems like this would be a ground. It's an area around the school, and then the statute would mean that you could take the gun in the school, but you can't walk from the curb over the grounds to the school if you're going to use the dictionary definition.
Well, I take some exception because there is no school on the grounds of the stadium. There's merely a football field and two parking lots.
But if we follow your definition of grounds, you can't have the gun from the curb to the door of the school, but you could have it in the school because the schools aren't grounds. And that's the common meaning of grounds under the definition, under the Merriam-Webster's dictionary.
Well, of course, in the statute, grounds doesn't stand alone, so it goes with grounds of a school. And I think that's the key part. So you can still use that definition of grounds that you're talking about, but it has to be connected to a school. And here there's no school.
What about school activities? Sporting events and extracurricular activities are not maybe, quote, academic. They don't get a grade, whatever. It's a school-sponsored event, a school-sponsored activity. It's part of education. Why wouldn't an athletic facility be considered part of the school grounds?
I think for the reasons that you said, there's no academics associated with that, no grade, no certified teachers at the Brady School Stadium. It's merely for entertainment purposes, which is sports.
Okay, if there's a concert in the band room, for example, or the auditorium, if there's a concert, maybe put on by a local band, but not school kids, but they go ahead and have it at the school. Are you saying that that's no longer school because it's not a school function?
I don't draw it that distinct, though I think I could, but if it's taking place in the school where academic instruction happens, I think then we could find that it is grounds of a school.
Do you have any evidence that there's never been academic instruction on the grounds at issue? Perhaps maybe PE. People do get graded for that. Maybe they go down and run around the track. Band. People get credit for band. Do you have any evidence that nobody has ever gotten academic credit for anything on those grounds?
I don't. That was not in the record. The only thing we gleaned from the record was that a football game was going on that night, and then sometimes the facility is used for public events.
What's the purpose of the statute? Isn't it to protect students from gun violence? And wouldn't that purpose apply equally whether the students are there for a school football game or in a classroom?
I think the first thing is if the legislature wanted to include it in school, they would have certainly put those words in the statute. But I would again argue that since no academic instruction takes place there, it shouldn't even be considered.
What's your case that limits school grounds for purposes of prohibiting weapons to academic classrooms? Have we held that?
You have not, no.
There, if there was the football game, if you read our Nicoletto case, you have to be a certified teacher or certified coach to be there, and they were on the premises at the time, and you don't think that extracurricular activities that are considered by colleges when you get admitted and all those things aren't part of the academics at the school?
I don't. To your first point about certified coaches, in my experience, there are some times where coaches aren't necessarily certified or teachers. They're just volunteers that are brought in to teach certain sports. And again,
You're Nicoletto, you can't do that. You have to have a certificate, even if you're a volunteer, and you have to be certificated, or you have to have a teaching license. So I don't know where that comes from.
Well, again, I think because I would contend that no instruction really happens on the football field at that point. It's just for entertainment purposes only. It's open to the public. There's no grade associated with it, and there's no actual teacher. But really the important part to highlight is this is really not attached to a traditional school.
So is the purpose of it enough? So let's say, for example, if we believe that extracurricular activities are part of the school's purpose, routinely state championships are held, for example, in Wells Fargo Arena, basketball, volleyball, wrestling, etc. Does that make Wells Fargo, in your mind, then grounds of a school for the purposes of this statute, even though there might be academic or extracurricular activity?
It does not. I would look to the purpose of what's happening at Wells Fargo Arena in the example you gave, and what's happening is an entertainment event. There's no teaching going on. There's no academics. There's no traditional school. There's no grading. So at that point, it would not be grounds of a school.
All right. Well, let's sort of go back to the statute itself, and then the statute makes it a crime, a felony for a person to carry a gun on the grounds of a school. Now, there isn't any limitation on what those grounds are. It doesn't say continuous or immediate grounds. It just says grounds of a school. So is that relevant in our consideration here? Or are you just arguing that because the stadium is not a school, it's not covered under the statute?
I think it's twofold. I don't think it's covered under the statute because it's not a school, but I still think you can look to the statute for grounds and school. And we talked about the definition of grounds with Justice Wiggins, but the definition of school is just simply an institution of learning and education, especially for children.
If the stadium was in the backyard of the school, would it qualify under the statute?
Maybe, yes.
Yeah, because it would be on the grounds of a school.
Yes.
So since the statute doesn't have any qualifying language like the backyard or the immediate or continuous grounds, would that be an indication that the legislature would have wanted the statute to be more expansive to include grounds of a school that are not necessarily immediate to the school?
No, I disagree. I think we do have instances where if they wanted to create distance, they would say within 1,000 feet of a school or something of that nature. Obviously, you're right, they didn't do this here, but I think they wanted us to interpret school in its traditional sense.
But it's grounds of school, not grounds or school.
Yes, grounds of school.
And grounds are different than the building itself. And if you're going to take literal definitions, you can have the gun in the school, but you can't have the guns on the area around the school, which makes no sense to me.
I think they go together. It doesn't say grounds or school, but it does say grounds of a school. So I'm not saying that the grounds around a traditional school wouldn't qualify.
What's the grounds of the state capitol here? Is it the parks out there, or is it the buildings on it?
I would venture to say it's the building and then the grass around the building and maybe the closest parking lots. But once we get out of those close parking lots, let's say we come across the street to the Supreme Court, that's no longer grounds of the Capitol, or across the street to the Lucas Building, that's no longer grounds of the Capitol.
Does it make a difference that Brady Street Stadium is owned by the Davenport Community School District, and there's signage to that effect?
I could see how that could be an issue, but I think because, especially in the instances where Mr. Mathias was in the parking lot, I don't think that it should be considered grounds of a school for tax purposes. And so, again, absent any definition by the court, and when a statute is ambiguous, the court must construe it in favor of the defendant. And since the court left it very open, very vague, very ambiguous, I think that it has to go in Mr. Mathias's favor. Are there any further?
Yes, I have one further question, and I just want to. I'm going to serve it up to you again. It's already been asked, I think, but the purpose of the statute is obviously to protect children. I mean, I think that's obvious. Maybe you can contest it if you want. The purpose is to protect kids when there's organized school functions. Why? I mean, to say that the Brady Street Stadium, which is owned by the school district, that has football games where the band marches and so forth, to say that that's not covered strikes me as a challenging position. Give me your best shot.
You know, one of the things I also do want to point out is because the statute is so broad and so broad, and it doesn't have definitions like 1,000 feet away, it didn't really put Mr. Mathias on notice that he couldn't carry a weapon in the parking lot, especially when he has the right. He has a right to carry. He has a carry license.
He seemed very proud of what he was doing. I mean, it wasn't like he had any idea that he was doing anything criminal, right?
Correct. And I think that's something that should be taken into consideration. And I do agree that the legislature's intent was to protect children, but I also know in the environment we're in, they also want to probably expand gun rights. So we just don't know which way they really intended to go as far as what grounds of a school was. And when we don't know that, we have to rely on the ordinary definitions. And so for those reasons, I ask that you reverse, one last thing I do want to say. Our second issue in our brief was that the district court expanded the definition of a school ground. He included cultural facilities, recreational facilities, and we argue that those are all definitions that are outside what the legislature put in their statute. And we believe that that was an error on behalf of the district court. And so I did also want to point that out. But for those reasons, we ask that you vacate Mr. Mathias's conviction. Thank you.
Ms. Stewart, thank you. Ms. Hines.
May it please the court, counsel. The district court correctly found that the state presented sufficient evidence that Mr. Mathias was on the grounds of the school when he was carrying a firearm on September 22nd, 2017. And that decision is binding on this court if it's supported by substantial evidence.
Well, Ms. Hines, let me start you out with this question. I don't think there's any constitutional grounds raised in this case. No void for vagueness or anything like that. But obviously, our statutes need to tell people what conduct is prohibited so that people can judge their conduct accordingly. And Mathias, was, as Justice Mansfield said, almost seemed pretty proud to be out there. So do we apply the rule of lenity and give the defendant, the benefit of the argument being made here that if the statute doesn't clearly tell people what they need to be doing, that we interpret it in a way that that is more strict to his argument?
No, because I don't think the statute is necessarily even ambiguous. And we don't get to the rule of lenity until you can't actually say.
Let me give you a couple hypotheticals based on actual situations in the Des Moines school system, which my kids attend. Des Moines doesn't have a home football stadium. They rent the Drake Stadium for Friday nights. Grounds of a school or not?
I don't think so, no.
Okay, let me give you another one. They have an administrative building located at 2100 Fleur. They offer online learning courses. The address given on their website for where the online learning courses are given from is the administrative building. Is that grounds of a school? If a parent went
Yes.
to the administrative building, they would be
Yes.
that would be grounds of a school.
Yes. The legislature actually did define what it meant by a public or private school when it referred back to Code Section 280.2. And that's probably the most broad definition of a public school or private school that you could find in the code. Even the
Let me ask you an additional hypothetical. So the Des Moines Public Schools also have a cafeteria facility where they have a central location where meals are prepared for distribution among the local schools. Is the cafeteria facility that's standalone where no classes are taught the grounds of a school?
I think if it's owned by the school district, yes.
So as I understand your argument, school means any property owned by the school district.
That is the argument.
So how would you account for the distinctions in Chapter 274 that distinguish between school districts and schools?
I think that you just school is defined all over this code, and it's defined differently all over this code. So at that point, if you're just looking, you need to look at what the statute says, and it says school under 280.2. And even the statute ahead of it, 7024-4A, defines school differently. It says public or non or private elementary or secondary schools. I think there's an argument to be made that this statute, by defining this public school as a school supported by whole and part by taxation, a college could be what this meant to get at.
If the code defines school differently, I think, as you said, all over the place, does that counsel in favor of the rule of lenity?
No, because when you read this statute, the legislature told the people of the state of Iowa that this is going to apply to places that meet the qualifications of a school, of a private school, and it's going to apply to places that are supported by schools that are supported by taxpayer money in whole or in part. I think that that seems wildly broad, but it should be, because this is a statute that is meant to protect students and people visiting schools. And that, as we all know, is especially significant in this day and age of school shootings.
Legislature has defined school grounds in other parts of the code. For example, assaulting a student who commits an assault against a school employee in a school building on school grounds, and it defines school grounds at a school's as a school-sponsored function shall be suspended for a time. The term school grounds makes sense. Smoking is prohibited in the outdoor areas of school grounds, which include parking lots, athletic fields, playgrounds, tennis courts, and other outdoor areas under. So they define it in other areas, and they don't really say what it is here. I mean, does that create a problem for you?
I don't think so. I think that by trying to make a more restrictive definition of it, it would defeat the purpose of the statute, because I think that they wanted this to cover as many places on the school grounds.
If you look at the assault one, it says, in a school building, on a school grounds, or at a school-sponsored function. I mean, how much broader can you get? I mean,
Well, the legislature is its own lexicographer, and I don't know. I think that it has, again, all over the code, there are so many definitions of school and even school grounds that the intent here, by referring back to 280.2, has to be that we want it broad.
I understand what the intent is, but we can't rewrite the statute.
No.
And we have to use the words that are used in the statute, and it says grounds of school. And my understanding of the ordinary meaning would be the area around the building, because in these other statutes, they refer to school grounds as parking lots and things like that.
Well, to me, that would be an absurd result, which I don't think the legislature intended, because in my high school, the football field was attached to the school property. It was contiguous.
Maybe an absurd result, but we can't rewrite the statute. Are we supposed to rewrite the statute to make it not absurd?
No, but it needs to be applied in this case in a way that the defendant's conduct falls within the statute. It did. The defendant was on the property of a school when he was at the Brady.
Actually, this is a ground of a school because under the normal definition, it's not the building; it's areas used by the school pertinent to.
Yes, under the definition.
So under that the ordinary definition, it seems that. But then you get the absurd result. What if the gun's in the building?
I think that the legislature counted on people to use their common sense on these matters, and that's why they made it this broad.
Does the record reflect which school uses this stadium?
I know Central High School does. It may be also used by North Davenport High School.
And does the record reflect the distance, if any, between the high school and the stadium?
I'm sorry.
Does the record reflect the distance between the high schools and the stadium?
No, not that I saw.
I mean, there are aerial photographs that show that Brady Street Stadium is physically some distance from Central High School.
That's
but
right.
In terms of notice to the defendant, there's in giant letters along highly visible from the street, Davenport Community Schools, that you see if you approach Brady Street Stadium, right?
Exactly, and that's why the constitutional vagueness does not probably was not argued in this place because.
Yeah, I'm certainly sympathetic to the policy arguments. I mean, people don't want other people bringing firearms to high school football games on Friday nights. That's not a good situation. But you know, in terms of notice, couldn't they have just put up a sign that said, you know, possession of a firearm on these grounds is illegal, and cited the code section? I mean, if they really wanted to avoid a problem.
They could have. They didn't need to. Citizens are presumed to know the law, and when it's marked as it was, it's difficult to assert that he would not have known that was a school area, school grounds.
But you're not arguing that all school property is covered. I mean, you're not arguing that, like, you know, give another Des Moines example. They have a school bus depot located up on the north side somewhere. You're not arguing that if a bus driver happened to drive into the depot with a firearm that he's licensed to have, you know, duly authorized to have, and left it in his car when he parked to start his bus route, that would be committing a crime.
I believe I am arguing that because I think that this comes kind of down to a property question. A school supported by taxation, that bus depot would be owned by the school and supported by taxation. So yes, in a sense. Mm-hmm.
Thanks.
And I think that makes a more usable line when you think of it that way.
Is the jury instruction faulty?
I think the jury instruction actually gave the defendant an advantage because I think that the court could have used the statutory language 280.2 and maybe I think grounds is a commonly understood meaning. So by restricting the jury in the way it did in Instruction 18, I think it actually made the state's job a little harder, and that would inure to the defendant's benefit. But even if it didn't, if the instruction was incorrect, there was no prejudice here.
Do you think that the way you're defining school here is a common usage? So if you were to say, for example, I'm driving to the bus barn, you'd say I'm driving to the school, and that would be a common understanding of what the word school means? Or I'm driving to the cafeteria and saying I'm driving to the school, that's a common usage?
In that particular instance, it might not be a common usage, but I still think the statute would cover that. And then maybe in that case, more of an instruction or a different instruction would have been helpful. But in this case, the Davenport School District owns the property of the Brady Street Stadium and the parking lot, and that meets the definition of a school under 280.2, which is what 724.4B requires. So it's not the best written law. It isn't. But I think that to the extent we can interpret something from the legislature's use of a very, very broad definition of school, we can say that it includes the grounds of the school, the property of a school, in this case that was public school that was funded by taxpayer money. The state requests this court affirm the defendant's conviction. Thank you.
Ms. Hines, thank you. You may present your rebuttal.
Thank you. I just want to address to Justice Wiggins and Justice McDonald's points about the rule of lenity. I think it does help Mr. Mathias that in other parts of the Iowa Code, such as assault and smoking, that school grounds is clearly defined, because we know
the rule of lenity doesn't apply until you, number one, find the statute ambiguous, and then use all the rules of construction and to resolve that ambiguity. And if you can't resolve that ambiguity, then the rule of lenity applies. Right. And if you look at the legislative history, you look at some of the bill notes and things like that, is it as ambiguous as you say it is?
I think it is. It goes to the point that if the legislature wanted to make it, wanted us to apply school grounds the way they have in other places, they would have put it in the language, and they didn't. And so that makes it overbroad, and it makes it ambiguous, and then we have to construe the law in favor of Mr. Mathias. And to the prejudice point with the jury instruction, when the district judge expanded the instruction to include all of these other things, he allowed the jury to then put Brady Street Stadium potentially in one of those examples he gave, recreational facility being probably the most pertinent.
But if we find that this place where your client had the gun was a grounds of school, the instruction would be proper.
Yes, but I do. If you pair them together, I think it'll come out in Mr. Mathias's favor, hopefully. And I will say one other thing as far as I think there were some examples given, some hypotheticals. The administrative building where an online course is, that's the address for the online course. I would submit that that isn't grounds of a school. There's no teaching that's actually going on in the administrative building.
Can I go back to the jury instruction for a second?
Yeah.
If the court didn't define grounds of school, would the parties be arguing the legal meaning of grounds of school to the jury?
I think so.
Is it the job of the attorneys to define what the law is, or is it the job of the judge to instruct what the law is, and then the jury applies the facts of that law? Because if you do what you're saying, it sounds like the jury determines what the law means.
Oh, of course not. It's certainly the judge that would define the law. And I think he went in this court, in this case, the district judge went outside of what the statute said and expanded it, and that's the argument that I'm making.
As I understand your position, you're essentially arguing your client was entitled to acquittal as a matter of law, because as a matter of law, this isn't grounds for a school. But at worst, it's a jury question, and therefore your client was entitled to an instruction that didn't kind of point the jury in one particular direction.
Absolutely, yes. And last, I do want to say, I think the last example was the cafeteria. not a cafeteria associated with the school, but I guess the depot that they distribute the food from. Again, I would argue that wouldn't be grounds of a school.
The prosecutor mentioned something that I thought was kind of interesting about how it's as simple as property ownership. For example, if the property at issue, if somebody wanted to use it, who would they ask for permission?
In this case, I do think that they asked the Davenport School District for permission. I think they said they do rent it out for public events.
And if the purpose of the statute, I think it seems to be undisputed, is to protect children, where do you think, what property that a school owns would have a moment of more children in one environment than a facility like we're talking about?
Well, certainly a school during the school day would have the most children.
In different rooms throughout the building, correct?
Correct.
And a stadium would have a lot of people in a very consolidated area?
The stadium would, but I think a school would have more, and I think that aligns with what I'm arguing, that a traditional school should be grounds of a school.
And just so I understand your argument, it's you're really arguing about the purpose of the facility, not its proximity to a traditionally understood school. Is that right?
I think it's twofold. I am arguing look at the purpose, but also this Brady Street Stadium isn't attached anywhere near a school.
So in the case of the football stadium that's adjacent to the school or on the same campus, you would agree that's grounds of the school?
Yes, that would get a different viewpoint because it's near the school. Again, for those reasons, we ask that you vacate Mr. Mathias' conviction. Thank you.
Ms. Stewart, thank you as well. Ms. Hines, thank you again. The case of State versus Mathias is now then submitted.